A very warm welcome to all the participants and my distinguished panelists. This today's webinar is very important because we are completing by this webinar 99th webinar. Thanks everyone for proposing confidence and support extended by all for our journey of this knowledge sharing. First webinar of every month is unique as it takes recap of all regulatory and legal updates in company law, security law, and insolvency law during the last month. And it's given opportunity to keep ourselves updated with the latest development and also keep what are the impact, implication, intricacies, and issues involved in these changes we want to discuss. Because every month the changes are not taking place. That's why we have added important case law, because that is also impacting the law and that is also bringing out the interpretation and the issues connected to that law. And this is one forum where all these issues of that particular month which has come new, we want to discuss, and then we want to give answer of all the queries of our participants. And all updates are also available on our monthly newsletter, CP Connect, which we are sending to all the participants, which we have already sent to all the participants. Friends, it's a moment of pride for all of us that today we are completing 99th webinar. And after the Diwali vacation, we have, after a 2 weeks gap, we are meeting again. Now, next webinar is on 100th webinar, that is Central Indian webinar. So you can understand that with the journey which we have started on last year on 2020 April, it has taken a shape, and now we have completed 99 webinar. So 100 webinar will take place on 18th November 2000. And in this webinar, this will be a corporate, the topic is excellence in corporate governance. And we are inviting the Secretary MCA, the Member of Parliament, the regulator from Income Tax, SEBI, the members relating to CCI, IBABI, and various other persons, they are joining us. So this webinar will be very important, and this is a webinar on excellence in governance, and everybody who is coming, all the distinguished invitees, those who are coming, they are giving interpretation of governance in their own area of expertise, own domain. So you can understand we have a regulator, we have a lawmaker, we have a industrialist also, and we have a professional also. So by this process, we will be in a position to tell the industry that what is the meaning of governance in the 100th webinar which we are doing. It is a very important, and it is very, I think, milestone for us, and the continuously without fail, except some few holidays, we have completed this. So I request everyone join this webinar and encourage us and understand from the people who's of the industry, regulator, and the government and the lawmaker. So you will find a new dimension of this subject. Now, friends, today we are having various subjects: company law, security law, and insolvency law. Some changes are there, not much change in company law, but there are changes in security law. And they have, the important is, they have given a framework of social stock exchange. They have changed the some aspects of the STD, that is insider trading. And then we have providing electronic book provider platform for IPO and debt securities. That is also very important change. And two important case law we want to discuss on insider trading, which Supreme Court has given, and another is the Bombay Dyeing case. So the insider trading cases, Abhijit Ranjan case is very important, where SEBI, the Supreme Court has said that even if you have done insider trading, but if it is not converting into profit, then it will not be insider trading. So that case is a very landmark case, and it will change the definition, meaning, and interpretation of insider. So various aspects of various case law in SEBI law, and the one case which is also very important, which has passed by NCLT, which is saying judgment pronounced without reasoning is not a judgment. And they are saying that this is also one landmark judgment which will cover various regulatory, quasi-regulatory, which they are passing order without reasoning, without justification. So that is also important. So we will discuss all these points today. So first I will start with our learned speakers, which are Anjali Agarwal, partner and head capital market service; Ankit Singhi, he is a partner head corporate affairs and compliance; Manoj Kumar, partner head in M&A transaction; and then Ravi Prakash, associate partner corporate professional. So they will start, and anybody who has any question, they can put in chat box, and we will give you answer during this. And some question which you are which after the program you are not clear, or there's some more doubt, you can write to us, we will reply. So now I will request first Anjali to cover what are the changes in security law. Most important is the SDD, and which Bombay Stock Exchange has given SOP, and then Social Stock Exchange and some other minor changes which has taken place. Over to you, Anjali.
Thank you so much, sir. At the outset, I want to really, I'm happy to get connected with my friends after a gap of almost 2-3 weeks. Diwali break, we are back. So now, when we talk about the regulatory updates which have taken place in the securities law framework, there have been 3 major circulars. One is pertaining to the e-book mechanism with regard to raising of funds through the non-convertible securities. The other one is with regard to the framework that has been raised that has been rolled out for the social stock exchange. And the third one is SDD framework that has been issued by the exchanges, and the FAQs that have been issued by the exchanges. So I'll share my screen. Is my screen visible?
Yes. Next slideshow.
Yeah. So when we talk about the securities laws updates, as I mentioned, the first circular that is there is with regard to the e-book mechanism, which will be effective with effect from 1st January 23.
So please check your voice is disturbing. Just check your voice.
It's not clear. Just a minute.
It is clear.
Okay.
Ankit, are you able to get my voice clear? Yeah. So I think it's better now. So the chapter 6 of the e-book regulations have been amended, and the same will be effective from 1st January 2023. Under the present norms which are applicable, so the bidding, the allotment is done on the basis of fastest finger first, wherein the allotment is made to the person who makes the bid first. It is on a time priority basis, and there were SEBI received certain observations from the market participants that this was not a very piecemeal distribution of the entire things, and as a result of which certain bidders who had actually worked on the pre-listing part were not getting the allotment. So it has been proposed that instead of fastest finger first, the allocation process will be on the basis of best bid process, which would mean that the person who's making the bids, all the bidders would be at par, and accordingly the allocations would be made. Simultaneously, it has been mandated that no eligible participant will be able to bid more than 100 crores or 5% of the base issue size to the arrangers on the e-book platform. Simultaneously, every participant has to give a confirmation to the provider that they have not used any particular software or algo or bots, as a result of which to give a priority to the bids that they have made. And everybody has to, the provider has to ensure that nobody is being given a selective treatment or a preferential treatment, and no bidding for anchor portion in the platform will be there. Apart from the above mentioned things, the norms with regard to the penalty or default cases, a very important change that has been made in the has been proposed is earlier under the erstwhile regulations, any issue size of more than 100 crores has to be done through the e-book platform. But now this 100 crores limit has been reduced to 50 crores. Plus, it has also been mandated that even for issues less than 50 crores size may be done through the e-book. Now, this was with regard to the raising of funds through the non-convertible securities.
Ma'am, your voice is not very clear. It's giving a
Not
lot of
coming clear? Okay.
not lot of disturbance are there.
Sorry, friends, for this technical glitch.
Hello.
Hello. Hello. Am I audible now? Yeah. So, sorry, friends, once again. Yeah. So now coming over to the social stock exchange, not everything can be with regard to money. There are certain things which have to be done for philanthropic purposes as well. So SEBI as well as the stock exchanges have rolled the framework for social stock exchanges and for raising of funds by the non-profit organizations. In the framework that has been rolled out, one of the provisions which was mentioned was that the social stock exchanges will formulate a social stock exchange governing council. So now it has been mandated that the social stock exchange governing council will have 7 members having representation from each of the following sectors, where one will be from the philanthropic purpose, philanthropic sector, one will be from the non-profit organizations, information repositories will be there, social impact investors would be there, social audit professionals would be there, capacity building fund would be there, and the stock exchange team would be there. So, next. Social stock exchange will prescribe the frequency and the periodicity within which this governing council will meet. It will also mandate the quorum for these meetings and the guidelines for handling the potential conflict of interest, and how frequently this council should meet and how many meetings should be held, with a minimum of 4 meetings in a financial year are required to be held. Then simultaneously, the governing council is expected to provide the oversight and guidance to facilitate the smooth functioning of the operations of the social stock exchange with regard to either registration or fundraising or the disclosures by the social enterprises. Next. Another amendment which has been brought in by SEBI is they have reduced the denomination of the debt security and non-convertible preference shares from 10 lakh to 1 lakh rupees. The idea behind reducing this denomination is to improve the liquidity in these scripts, when these scripts are also being listed on a regular basis at the exchanges. So it's important to provide liquidity as well. So with that intent, this denomination has been reduced. Now, the most important aspect of the entire framework pertaining to the listed companies. This is structural digital database, and during last 2 months or so, 3 months or so, we have observed that listed companies were little preoccupied with this entire thing of structural digital database, wherein listed companies have to maintain a digital database so that every entry pertaining to any UPSI is entered therein, which should be non-temporable, which should be properly dated, and it has to be certified by a practicing company secretary. So for the quarter ended 30th September 22, the last date for submission of this certificate by the PCS is 18th November 22. And for the quarter ended December 22, this last date is 21st January 23. So every listed company, the compliance officers thereof have to be very careful that these dates are not missed out. Now, along with these timelines, SEBI, the stock exchanges have issued certain FAQs as well, which are very important for each of the companies to keep in mind as to what exactly is a SDD, or at what point in time the entry is needed to be made in the said database. So who all are required to maintain the structural digital database? From the PIT regulations as well as from this FAQs which has been issued, it has been very amply clear that every listed company, every company proposed to getting listed, any intermediary or fiduciary which is in possession of a UPSI is needed to maintain this SDD database. Then a very pertinent question which comes to everybody's mind: at what point in time should we make an entry in the digital database? So, because at the board level, there are many things which are discussed, which are just discussed, wherein it may convert into a corporate action or it may not convert into a corporate action altogether. So at what point in time, what is the trigger point for inserting a record in the SDD? So it has been clearly mentioned that when you share any UPSI, whether internally or with external agencies, that is the trigger point wherein the information is needed to be put in the SDD. So as a consultant, if a company is approaching me that they want to come out, they want to declare a dividend or they want to come out with a buyback, so it becomes a UPSI, and the details of the people who are privy to this information are needed to be recorded in the database. Then another question which has been answered is, when is a UPSI germinated? The above question was with regard to entry in the digital database. Now, when is the UPSI germinated? Now, there is a very thin line difference between these two questions. So when the probability of going ahead with a particular information or the transaction is higher than not going ahead with it, then and the information is likely to materially affect the price of the shares or the securities rather, then that is the point wherein the UPSI has been created and the insertion in the digital database is needed to be made. So there are certain requirements pertaining to these SDD. Database shall not be outsourced. It has to be maintained with adequate internal records. Time stamping has to be there. Audit trails have to be there. And non-tampering of database is one of the important conditions which have to be looked into. Entries once made in the SDD cannot be altered or modified. These things have also to be kept in mind. So can this, so a software, but however they have allowed that a software can be used to maintain the SDD. However, this has to be maintained internally. It cannot be on the cloud of any other agency. It has to be maintained internally. There are many groups which have multiple listed companies. So it has been very clearly mentioned that every such company, every listed company has to maintain an independent SDD. The way we have independent compliance officers in each of the listed companies, likewise, in every listed company has to have independent SDD as well. There have happened certain situations wherein the consultants or the agencies, intermediaries say that why do I share the PAN of my employees? So it has been made very clear that PAN of all the people who are dealing in the particular transaction or a corporate action have to be obtained and they have to be captured in the STD. Over to you, Pavan sir. These were the amendments that were there in the securities laws.
Okay, Anjali, just go back. So you mean to say the now the SDD law which is there and BSC has given SOP. Now they have, because various questions the professionals were asking, corporate were asking. So as per you now, all the points are clear. Hello.
Sir, I don't think so. That points are still clear.
Yeah.
There are a lot of issues with respect to with respect to entering of information being shared internally, because that is shared on a very routine basis and on a very frequent basis. So entering which information to enter at what point of time, it will be difficult for companies to ascertain. And another important point is as a part of the FAQs. In one of the question as to when information will be treated as an UPSI, in response to the answer, it has been mentioned that when that information is, there has to be a reasonable sense of certainty or possibility of being that converted into something real. So that opens a lot of doors in terms of interpretation, because generally in how we perceive it, for example, if I am working on a acquisition and I have started preliminary negotiations, started due diligence, and so all the parties who are engaged are deemed to be part of the UPSI. I may, after the diligence, decide not to execute or purchase it, but if there is a term sheet that has been entered, negotiations have reached to a particular stage, I have also done the due diligence. So identifying only when it is very concrete or it is very certain that the deal will go through, there are questions which needs to be answered on such case, and it will open a lot of interpretation related issues and will create more confusion among us corporate as to when to determine that there is a certain degree of certainty.
Okay. One confusion is there, which I think Anjali and Ankit can tell us, that PCS or compliance officer. So it means that certificate by PCS or the compliance officer of the company can give.
So
Is
either of them.
Either of them.
So as per the earlier communication that was received from BSc particularly, it was mentioned that the certificate needs to be certified by PCS from next quarter. But now when the final blueprint is out, they have not casted the responsibility as a joint responsibility on both the compliance officer and the PCS. Either of them can give this certificate now.
Okay, is there any impact on this?
Sir, so impact, I think when an external party is giving a certificate, then while the degree of reliance is both in both the cases, because as a compliance officer, if he is also certifying, he is certifying basis some understanding and similar basis. I think a lot of compliance officer, like for a lot of clients we deal with, they just want to have certificates from PCS to have more clarity, because there are a lot of issues where there is confusion on this SDD. So taking a certificate, getting some kind of audit will also help them in concluding the practices and processes they are following are right or not. So that is why resorting to PCS can also be one of the way to submit the certificate, but options are available for both.
So it means that is very clear that people are understand that the normal person is understanding this way, that insider trading is relating to the company and the working in the company and few people. But now, after this SDD and the interpretation of law, it is clear that there is a possibility that you are a consultant in a company and you have a full team which is working. So it means that your organization is also coming into that category, and you have to protect your information, which should not pass on to other people, and the law should not be applicable to you, or law should not come on your head, on your way.
I think so it is a dual responsibility. If I am sharing a responsibility on the fiduciary, there is a responsibility at my end, but there is also a responsibility at the end of fiduciary to make sure that the UPSI is being used in compliance of the provisions of the PIT regulation. And they have to create their own code of conduct, and in sometimes they will also be having this SDD of their own. One of the things which is now very clear from the circular is internal sharing of UPSI is required to be entered. So even if financial results once prepared are being shared between functional heads as part of discussions, so that may also be required to be entered in the SDD.
Okay. So friends, these are the some few changes in security law. Now there are two important judgments has come in this month. One is the Bombay Dyeing promoter Wadias bar by SEBI from securities market for indulging fraudulent acts, imposing 13.25 crore penalty. Now, the penalty, another thing is there, but the question is, there are two things happened in this case. One is misrepresenting financial statement, so various accounting standard issues, various interpretational issues, whereas other subsidiary and holding the company's information. And then there is another part which has taken place. The SEBI has put a penalty on independent director also. And these are the independent director are not the normal independent director. These are the top-notch independent director of the country. And SEBI has put in the penalty. Now this particular thing will open a Pandora box, and every independent director and this institution will require more scrutiny, more information that is important. And Ravi will also discuss about one company law case, and Ankit will also discuss where they have put in responsibility on independent director for making the defective medicine. So that is also, so the two important case has taken place during this month relating to independent director's responsibility, which has to be discussed in detail, and the consequences and the prerequisites and what you have to what precaution you should take. So Ravi, I will request you just start this case of Bombay Dyeing first, and in the Bombay Dyeing case, you please cover the independent director issue also. So Ravi and Manoj, you please. So Ravi, you start.
I think we need to change the slide. Vivek, can you take it to the Bombay Dyeing matter?
First Bombay Dyeing matter, Ravi.
Yes, sir. I think next one.
Next one,
Next.
Vivek is operating.
After,
Yes.
after the security law, you go just cross all these things. Yeah, go next. Next. Yeah, next. Yeah, this case.
Yes, this is. So, very good evening, everyone. As you can see on the screen, the amount of penalty is hefty. But if you go through the order, it's a 100-page order. And the order is itself hefty and heavy. What it notices, let us understand the factual conspectus in which the case arises. So Bombay Dyeing as a company has three major verticals, which is one is polyester, another one is real estate, and third one is textile. And the order lays down a chart which tells you that during the investigation period, which is financial year 2011-12 till 2018-19, the real estate sector, while the polyester segment was the one which was making revenues more than the real estate segment till financial year 16-17, it was the real estate segment which was the most profitable. And after 16-17, you see a bull rally in the real estate sector segment of Bombay Dyeing. And this was a matter which was taken up by SEBI upon complaints and after the investigation being conducted by the regulator. So let us understand what probed SEBI to look into this issue of misdeclaration or misrepresentation in financial statements, which has, as per SEBI, inflated the financials by thousands and crores of rupees. So SEBI says that the real estate segment of Bombay Dyeing was one of the lucrative segment, cash cows for Bombay Dyeing, and 50%, more than 50% of this segment was being undertaken with another company known as SCAL. Now, this SCAL is an unlisted company situated in Ballard, in the same building where the offices of Bombay Dyeing were situated. And these are all the findings of investigation. So number one is more than 50% of the real estate business is being done with a company, an entity called SCAL. And SCAL is situated in the same building where Bombay Dyeing is situated. SCAL is manned with directors, officers who are the employees or officers of Wadias group of companies. The directors of SCAL are not being paid remuneration from SCAL, but they were drawing their remuneration in perquisites or emoluments from the Wadias group of companies, wherever they were respectively placed. So what went wrong for Bombay Dyeing in this? What was found to be an illegality in law by SEBI? So SEBI says that as per the guidance note issued by ICAI for an entity which is in real estate business, before recognizing any revenue, they have to test it on three principles. One is that all the risk, significant risk and rewards of ownership. As you know, in real estate business, Bombay Dyeing was into selling flats in Mumbai. And this matter surrounds around sale of 325 flats for more than 3,000 crore rupees, precisely 3,033 crore rupees. So before you recognize the revenue in your books as a real estate business, you have to ensure that all the significant risk and reward of the ownership has been transferred to the buyers. It is not lying with you. It is not unreasonable when you are recognizing the revenue in your books to expect ultimate collection. It means the chances of ultimate collection are not unreasonable. They are reasonably within the limits that you can collect them. Third is that there is no significant uncertainty regarding the amount of consideration. So it means that there must be reasonable certainty it all goes with in line with the principles of true and fair view, that you should be certain with all reasonableness that what you are recording in your books is what you can achieve in terms of the commercial work, in terms of your commercial transactions. Now, SEBI observed that SCAL is nothing but an entity propped up by Wadia group of companies and Bombay Dyeing, being controlled by all these people collectively. And then business dealings were done between them. This is the allegation. This is the linchpin of SEBI's allegation. And they said that up till certain period of time, Bombay Dyeing was holding 49%, which was the main pivotal point of connection between the Wadia group of companies and SCAL. But thereafter, it diluted the stake below 20%. Now, the readers of Companies Act would remember that this act defines associate company as a company with significant influence. With the investor company, this could be in terms of 20% shareholding of 20% or by control, which is to that extent. So therefore, even though the shareholding was diluted less than 20%, but as SEBI found that there were the Bombay Dyeing was able to control SCAL through the Wadia group of companies, they postulated that it was a farce created by Bombay Dyeing to inflate the revenues, whereas the actual flats were not sold to the ultimate buyers. And out of this 3,033 crores revenue which was booked in Bombay Dyeing's financials, the SEBI order says that close to only 8% has been ultimately recovered. And as I told you, one of the three principles is about the certainty of ultimate collection. And all this has been done more than 5-6 years ago. And so far, only 8%, close to 8% has been collected. So they said that you violated Ind AS 7, accounting standard 7. You breached accounting standard 23, which is also couched in Ind AS 28, which says that if I have an associate company, so all the unrealized profits and revenues would be eliminated to the extent of my interest in the investee company. If I share the relationship of associate and fall under the ambit of accounting standard 23. Now, another important point is that in FUTP regulations in 2020, there was an amendment that if there are fabrications or falsifications of accounts by a listed entity, that also falls within the dragnet of prohibition of unfair trade practices and manipulative trading regulations. In short, FUTP regulations. So therefore, collectively taking the non-disclosures, misstatements, and a deep-rooted scheme which allegedly Bombay Dyeing followed to prop up SCAL, deal with SCAL, book revenues in the financials, and then to ultimately mislead the non-promoter and public shareholders, is the entire fraudulent or deceptive scheme based on which the charges of fraud are leveled. And they say that the directors and officers of the entities, and let me, before I go on to the legal aspect, let me add one more leg to the factual conspectus of the matter. While testimony, as we know that when SEBI does an investigation, they also collect testimony or the statements of persons. One of the notices who was a CFO, he stated that dilution of Bombay Dyeing in SCAL from 49 to 19% was done so that SCAL is not appearing as associate in its books. Now, this brings in the motive as to why you are taking those actions. So therefore, on the basis of the reasons and the pointers which are recorded in the SEBI order, it's a more than 100-pager order, a 100-pager order rather. which postulates all the reasonings, all the facts based on which a collective view has been taken that this is a case of fraud, a deep-rooted scheme of fraud and deception to inflate the financial figures and to somehow inflate the prices and affect the price discovery mechanism of the market. And therefore, they have punished not only monetary penalty, as you see on the screen, of 13.25 crore on the promoters, but also on the directors of SCAL and other persons who were there in the Bombay Dyeing as well as SCAL. The common observation of SEBI was that none of the director was able to showcase with conviction that he or she discharged the position of fiduciary duties that were expected of them. And that is the reason SEBI has penalized and also debarred the promoters as well as some of the guilty persons from not holding position of directorship in connection with securities market or any key managerial position in relation to securities market anywhere for the period of bar they have imposed on them. The period of bars are 2 years and 1 year, respectively, for the categories of notices based on their roles. So this is what, in nutshell, the order is. Now, coming to the other side of the matter. What
Ravi,
is the difference? Yes, sir.
just add a couple of points since before you conclude. So
Yes.
there are a couple of important things that we also need to look into. Is that how this inflation was done, how the revenues were inflated. So there is a accounting standard which provides a criteria where you can recognize revenue. And there are certain characteristics which needs to be fulfilled in order to recognize that revenue. So the purpose they used SCAL, their group entity as one of the entity, to create, to enable to meet all those characteristics so that the revenue recognition standard is met and they can recognize all the revenue because they're actually being realized. First and important thing. Why did they brought their shareholding to 19? It's not just because they want to keep it out of associate. There is a reason why they want to keep it out of associate, because since if it was an associate, there will need a consolidation. If it needs to be consolidated, then there will be some cross balancing of figures, elimination of figures, which will have an impact. And some other points that they also mentioned that SCAL's net worth was negative.
Yes.
The money that SCAL paid towards the MOU was borrowed from other group companies, other group companies of the Wadias group. So it was a very connived transaction where the entire group acted in concert to create a sales which is not in actually that was a sales to recognize that sales. So that's the main object. And but there are two important points which I can gather from the order is that SEBI, while they look into the related party transactions, there are two definitions under the Companies Act and their accounting standard. Companies Act is a limited standard, accounting standard is a little comprehensive. But I've seen SEBI tend to go beyond even the limits of those definitions and try to find out and look at from the lens of if they were in any way controlled directly, indirectly at any level by common persons, then they treat them to be part of same group. So there may be cases that one entity might not be fulfilling the criteria of related party in terms of accounting standard, but because of far connections associated with it, SEBI considers such entities as part of the group. And specifically for Nusli Wadia, they have specifically mentioned one word that while he is the MD, he is also the promoter. And one important point they specified that the quantum of transaction was such huge that it cannot be executed without the concurrence of the managing director.
Yes. Rather, they have said that these are so huge that you cannot say that you were not aware of them.
Yes. So the transactions, the quantum was such that you cannot say that MD was not aware. So far as independent directors are concerned, I think the more question is with respect to, we need to look into as to how far the genuinity of a transaction needs to be looked into. Because for independent directors, I was discussing with some other person also, what are the ways they can ascertain? Internal auditor report, arm's length pricing, statutory auditors report. These are something which rely to conclude and ascertain how the processes are being followed. Yeah. Expecting them to look into each and every transaction and go into details, it's a very Herculean responsibility that is being put on them. But yes, definitely it cannot be said that they can just be deaf and blind. They have to apply some mind. It needs to be looked into what kind of mind they've applied, whether they were acted prudently or diligently during that course of time or not. And that's while it's very subjective, at times it's very difficult to prove also. So I think these are some of the points I want to make.
Ankit, Ankit, it means the impact of this case. Manoj, what is your view? The impact of this case. Now, independent director can verify, because I'm on behalf of independent director talking. They can rely upon the auditor, internal auditor, management certificate. They cannot go and check each and everything. They can't be watchdog. Okay. Or I should say hound dog. They are the watchdog. They are getting information what you are providing. They
Right.
can, but inside the information, if you are manipulating, if you are doing things, how they will be responsible? Manoj.
So I think
So they are
we have to-
watchdog with very strong nose.
Sir, I
what
think
SEBI
we
expects.
have to be very much careful about which organization it is. If someone is, let's say, it is a big organization, well known, hundreds of years of history, having a lot of assets. Let's say there should be some reason of doubt on the basis of which the independent director may go deep into the things. So what we are discussing is the present scenario which is being presented, which is investigated by SEBI. But there may be some other side of the story also, because what property was being developed is a very prime property. It was a factory, Bombay Dyeing factory at one time, and it is centrally located Mumbai property, which must have the value as maybe being disclosed to the board of directors, to the independent directors. So there may not be very big reason to doubt about the integrity or doubt about the valuation being projected or turnover being projected by the company. But yes, because they all are the sometime member of the audit committee, which is supposed to know deep into the financials of the any company. They should have basic knowledge of the finance and accounts, and hence they are being questioned. They should have questioned why you are now diluting the stake in SCAL, which is also not earning something, and you have a MOU. Why? Those things should have been questioned by the independent directors. But practically, if a very senior big businessman is giving a presentation that a huge property is being created here, which is in central Mumbai, and its value will be 3,000 crore, nobody questions, because it appears to be genuine. So that, I think that is the reason, and I don't know what is the actual valuation, actual sale achieved by the organization till now. But I don't think it should be a challenge. 3,000 crore rupees earning from 300 flats in the center of the Mumbai may not be a big challenge. So I don't know, and I think Bombay Realty has a track record of already delivering certain properties. So those are the contradictory situations. Accounting juggleries are there, frauds may be there.
Manoj, you meant to say as a director, I should go and check the price of the property and the.
Even if that's what I'm saying, even if they would have checked, Central Delhi's price is such that it can easily be corroborated that the valuation is being justified. It is justifiable by valuation. Whether actual sale has happened or not, that should have happened because there is an intermediary company which is SCAL. Now SCAL is selling to third party. So what revenue is coming? What is the term of recovery of money? Those things are deep things which need to be investigated. But apparently, every time the board must have got the presentation that this is being developed, this is the site, this is all those things, and this is the standard pricing in this area, and we will achieve that. So there is very little chance of doubting the revenue and projections. That's why I don't think they all senior learned independent directors could have got deceived, or if it is the case, I don't know what will happen in the appeal. They will certainly go in appeal, and what will be the outcome, nobody knows.
Because it's
It is
very
because-
technical.
Sorry, so sorry, what?
It's very technical. So there
Yes,
are accounting
so-
jargon, so it can be
would require- if it
interpreted.
is a-
One
if it
can
is
establish.
fraud, then it is a very big thing. But in it is some investigation by one team of SEBI, which may get totally turned to other side if the matter goes in appeal. So we have to just hold the things. But yes, it is a very big challenge for independent director. What is their total liability, responsibility with respect to financials of group companies, related party transaction, all those things. They have to be on their toes now.
Okay. So now the impact of this case is we can understand the SEBI is going into different way. The investigation division is becoming very smart. They are not only seeing what is law, but they are seeing what is not written in the law, but circumstantial evidence is creating something. That is one. Number two, today, the independent director's responsibility, which is put in by the SEBI, it is also alarming for all. And I think you have said very easily that the independent director should have done this. But now after this case, and these are the directors who are who's and who's of Indian Independent Directors Institution, they will raise the other director will raise the issues now, and they will see that all these compliance, all these issues should come in a way. How the things will take place is a very is a Herculean task also, and it's a very big issue. Let's see that where it will come. But this is clear that SEBI is not only seeing one part; they are seeing 360-degree. They are seeing searching, doing, and very smartly they are working out. So everybody should be alert on this. Independent director should also realize what Manoj has said. Wherever you have doubt, you should not depend upon the independent director. You should check independently also. That is another thing. How far it will go, that's a question. So thank you. Ravi, anything add you want to add in this?
Yes, I just want to add one thing in this. That SEBI has cracked on this entire case based on the publicly available information. The commonality of directors, commonality of control, commonality of interest, financial arrangements between SCAL and Wadia group of companies. And this is what raised a suspicion. Of course, there was a whistleblower complaint, if I may put it for lack of better words. But then SEBI did find out based on the publicly available information. And that is why I said that SEBI in the facts and circumstances of the case found that the responses from the directors or the office bearers were not satisfactory, that they have discharged their fiduciary duties. For example, one of the defense taken in the order, which is recorded in the order, is that there is no dealing in the securities, there is no manipulation, there is no such assertion or allegation in the SCN, then why the charges of FUTP are leveled? Simply, now it is another legal question that the amendment, including the misrepresentation of financial statements, came in 2020. But the investigation period here is 11 to 19, financial year 2010-11 to 18-19. Now, that is a legal question, completely legal question. But then, apart from just touching on the legal issues, I think SEBI would have been, should have been given some material to showcase that the decisions were taken in better commercial interest of the company as well as the shareholders. And there is no illegality per se, because accounting, the application of accounting standard principles is subjective as well as objective. One cannot lay down a thumb rule principle. It depends, it changes as per the nature of business, as per the exigencies of business, and as per transactions. So therefore, I think, and you do not second guess the judgment of board usually, unless until you find out with something cogent evidence that board has gone wrong in taking decisions. So I think board should have satisfied, people should have satisfied SEBI on those aspects as well, which is found to be lacking in this case, at least going through the order.
Okay. Okay. Thank you, Ravi. Thank you, Manoj and Ankit. Now, another very important case which has taken place in security law, that is on insider trading. The Supreme Court, this matter is SEBI versus Abhijit Ranjan, where say the mere possession of sensitive information not enough. Actual profit motive essential. Supreme Court uphold Gammon India promoter Abhijit Ranjan acquittal. Now the point is that till now the law was there that you should have a price sensitive information with you and you have traded in the security. So the trading of the security and the price sensitive information, two things were the test. Now SEBI has put in this insider to benefit or gain from unpublished price sensitive information, that is important. If you have purchased some shares with the price sensitive information is with you in the reverse direction, in place of profit you have incurred loss, then it is not insider trading, which earlier it was identified as insider. So Ravi, please explain this case and then we can see this, how it will impact this.
I think the judgment is as simple as you have put it. The point is this, that one has to see the motive, not just the fact that one has traded based on UPSI. That is the sum and substance of the judgment. Because, and I'll tell you why Supreme Court has held so in this particular case. Nevertheless, as legal fraternity and as the subject of legal fraternity law itself evolves continuously, so it cannot be said that this is the last mile development in the realm of insider trading law, but certainly this is something very substantial and something which would give a setback to SEBI, which has been deciding cases based on the presumption that if you trade based on UPSI, nothing doing, no further thing, you have committed the violation of insider trading. So without much ado, let me go ahead and tell you from the Supreme Court order, what are the preconditions to allege the violation of insider trading, which is the violation of Regulation 3 of the regulations. Number one, the person must be an insider within the meaning of the word insider as defined in the regulations. Second, the information that such person has received or has had access or reasonably expected to have had access should be unpublished. Third, such unpublished information should come within the ambit of price sensitive information. And fourth, he must have or she must have indulged in the trading either by dealing in securities or in communicating or counseling or procuring directly or indirectly any such information to any person. Now, the disclaimer before I go on to explain Gammon or Abhijit Rajan's case is that the principles laid down in this judgment only deal with the first part of the law, is that if you are trading on your own in the security, if you are doing tipping off, if you are passing off the insider information, that would be governed by some different principles of law, which have not been argued in this case. They were not even the subject matter of the dispute which arose in this case before the Supreme Court. So one thing which we need to take care in mind while interpreting Gammon or Abhijit Rajan's case is that it only deals with when the charges of dealing in the securities based on UPSI. Now, what are the questions one must ask? The obvious questions one must ask before adjudicating an issue of insider trading. Is the person an insider? Did he possess or have access to any information relating to the company? Whether such information was price sensitive, whether the information was unpublished, and whether he dealt in securities by subscribing or selling or dealing in the securities. Now let us see the facts. What were the facts of this case? Mr. Abhijit Rajan, who was the respondent, because this was an appeal filed by SEBI against the order of Securities Appellate Tribunal, which had already exonerated Mr. Abhijit Rajan in this 2013 matter. The matter was that Mr. Abhijit Rajan had sold shares, 1,44 lakh shares of Gammon before resigning as a chairman and managing director of this company. And this sale was done on 28th of August 2013. Now, let us see what happened before, just right before this sale and right after this sale. And this was not a small sale of shares. These were 1 crore 44 lakh shares. So on 9th of August 2013, there was a termination of agreement, a shareholders agreement, which was disclosed to NSE and BSE on 30th of August 2013. So from termination till its publishing, which is disclosure to the stock exchanges, on 22nd August, there was this sale by Mr. Rajan. This is the bone of contention in the matter. So he was a managing director. That was an admitted fact. It is also an admitted fact that the shareholder agreements were terminated. Now, the dispute arose. So SEBI was saying that he sold the shares because he knew that after termination of agreements, if this information goes public, shares will tumble down. So therefore, he has tried to avoid the losses by selling the shares while the information is unpublished. Defense on behalf of Mr. Rajan was that when you test this information, its effect on the market, it would be positive. Because after terminating these agreements, Gammon would get better control, better realization of value in terms of commercial transactions that were envisaged in those agreements. Also, another point which was raised in defense for Mr. Rajan was that the contracts, although they were running in thousands of crores, one of which was 1,648 crore rupees contract that was terminated, but order book value of Gammon. So this was also inconsequential. Now, while Supreme Court in this judgment has said that in the principle of de minimis, which is that I have just done a small trading, small number of shares is not applicable in insider trading, they did said that you have to check that the price sensitive information you are saying, what is the nature of that? What is going to be the impact of that? What is the sensitivity? Whether the sensitivity is that it will catapult the shares or the sensitivity is that it will plunge the shares. So therefore, you have to assess and apply the sensitivity in the real world, not imaginarily. And therefore, when in Gammon, the impact was actually positive and he sold before the positive impact came into the market, you can't say that he did insider trading because there could have not been any motive for insider trading. This is the sum and substance of the judgment.
Okay. Ravi, Ankit, you have any point on this?
Ravi, so is this a case of mens rea?
Yes, very $1 million question. Mens rea, no, not mens rea, but it's an essential circumstantial element which the court or authorities must satisfy because the sensitivity has to be tested. Ultimately, the sensitivity is the important thing, sensitive information. So what is that sensitivity? So if the sensitivity is positive and I'm selling before it is unpublished.
So that is what mens rea, no? If I am trying to take
So
benefit out of it
so
in any way.
intent and motive. Actually,
Yes.
we have already, Ravi has told about 4 tests, but the 5th test is also that you are trading based on the insider unpublished prices info. So whether it is based on that, your decision is based on that or not is a very critical test, and that test has been checked here. So I am selling.
Manoj, I think that is very difficult to even establish whether that
but
influences
the
your
regulator
decision
is
or
doing
not.
the investigation after 5 years, so they could have, if they are making assumptions, they should have looked into the facts of the circumstances now, because it is a hindsight decision, right? It is not the real-time decision. So decision always happens at hindsight. So you have to see the circumstantial evidences also. That is where the SEBI failed, and hence the SAT reversed the order, and then it went to Supreme Court. Supreme Court also upheld the order of the SAT. So reason is simple. If the intent of sale was not to gain or to avoid losses, then it cannot be considered to be insider trading per se. Yes, it may be technical violation that you are having, your window is closed, technically closed, and you cannot trade. So that is a technical violation for which you can put small penalty. But the real insider trading happens when the trading is based on the insider information. So whether it was based on insider information or whether he was being kicked off the company and hence he has sold his shares. So
Manoj.
that the motive intent is very important.
Manoj, the point is, in this case, they have distinguished between mensory and profit motive. Now, the point is, the motive word should not go separately. The motive
Yes.
word along with profit should also go. So now the
Yes.
question is, I have information and
Yes.
I came to know that company will lose, the share price will go down, and I'm selling. It means I'm avoided my
Losses.
so
Yes.
that is a profit. Okay.
Yes.
Second is that I have information and I purchase shares because the company share price will go up. In both the cases,
Yes.
both are the reverse. One is plus,
Right.
minus.
Either to gain profit or to avoid losses, both are same.
Okay, both are the same thing. Now, in this case, if you read carefully, SEBI is saying you have price sensitive information.
Yes.
That is not a
No
crime.
doubt.
Then you have traded. That is also allowed in certain cases. Okay.
Right.
But if you are having information and selling to get profit
Or to avoid loss.
and avoid loss, it is crime. But
It
if
cannot be proved, but it could not be proved by SEBI here.
if it is reverse, like I have information and I sold shares and price has gone up, it is not, as per SEBI, it is not a violation.
Yes, because the trading should be based on unpublished price sensitive information. So whether it was based on that or it was just because of my possession, you are alleging me. That is the case, no?
But there is an important angle to it in terms of the circumstance. For example, if someone's mother is having cancer and he or she needs money,
Right.
he or she has shares of a company for a long period of time.
Ankit, that is not exemption if it is a profit.
No, sir, that is what, sir, but it is also important what motivated
What is
that.
the motive? Actually, what is
Yes,
the
so I
is
am
the
not
reason
trying
of
to
this
take profit
transaction
out
dealing-
of that UPSI. It's because of my duration, there is a profit in terms of increase in value, but the decision is motivated by my immediate needs, which is not driven by the UPSI in my position. I may make some profit because I might have purchased shares a long back, but it was not motivated by that information. It is motivated by a need, which is something which is beyond my control.
So in that case, sir, if I may add, that is exactly the another point which was argued in Abhijit Raman's case, this very case which we discussed.
Yes.
So he sold those 1,44 lakh shares to save the company, to infuse funds in the company. And he showed that emergency. So that was a valid defense. But you might not be charged with the allegation of insider trading in that case, but certainly that would also be a violation as pointed out by Manoj sir. Secondly,
technically, yes.
Yeah.
But
secondly,
what is important, it was motivated by that UPSI or not. My
Yes.
sale was motivated by that UPSI.
So the motivation should be the profiteering motive. The motive should be that you want to encash unjustly on the asymmetry of information.
Yes.
That is the, I think that is the bottom line of the test.
So
Now,
I don't
secondly,
think
that one thing
anything-
is,
Yeah.
sorry, sir, you were saying something.
Yeah, so I don't think it has changed anything drastically in the situation or the established law. Yes, the practice, SEBI people may have to modify their way of dealing, but it is not changing the actual legal scenario of the case of
But
insider.
Manoj, I think both this case and the one of with respect to PC Jeweler has certainly put SEBI in
pressure
some
on the
back foot.
investigation
There is a
Yes.
lot of pressure on
Now, I'll
SEBI
tell you-
because that case was also very important in terms of ascertaining.
I'll tell you something interesting here, as Manoj sir pointed out, this based on the expressions and terms based on UPSI.
Yes.
If you read the old regulations and compare them with the new regulations, the new regulation says with for the allegation of breaching regulation 3, possession is sufficient in law after amendment. Earlier, it was based on UPSI.
Based on the word
Now,
there. Yes.
even though they have changed the law, the judgments from Supreme Court has relegated SEBI to the backward position that no, it has to be based on,
Yes.
not mere possession.
Because
Based
it is
on
a
with
basic
intent to
regulatory
gain or
law.
save
loss.
It cannot go beyond the basic concept of law. So
Yes.
the section SEBI Act itself provides that insider trading is prohibited. So insider trading and regulation need to be made by SEBI. So SEBI can expand it make it clear, but not change the basic definition. Basic content cannot be changed.
Victimize. Correct.
Okay.
Ravi, just one thing. Any difference in judgment would have happened if this case would have happened in the present scenario, wherein on one side regulator is saying that a SDD is needed to be maintained, and at every point in time the transaction is needed to be entered in the database. As per meaning thereby, Abhijit Ranjan was aware that this agreement would be terminated, and the discussions were going on with that other party, and the agreement is to be terminated, and that is being recorded in the database. And as a result of which, when he sold those shares, he made a profit out of it.
Ma'am, I don't think there is any denial that he didn't possess UPSI at that point of time.
Yes.
There
There
is no
would have been-
denial.
there is
I
no
think that
denial.
is not the question, that whether there was an entry in SDD or not. The question is that when you transacted, the circumstances which forced you to transact, and whether you transacted to make profit or to avoid loss.
Avoid losses.
Okay, okay. So now I think this case will go a long way, and SEBI is working out and they are giving. So thank you, Ravi. Thank you, Ankit, Manoj. Now, the very interesting case in insolvency law has taken. This is
I think, sir, there is one more case related to directors only, if you want to take it now.
no, Ankit, I'll take up because
Okay.
okay. So this case is also very important, and judgment, no doubt, is a pronouncement by NCLAT, but it will apply across the country, and in all cases it will be judgment pronounced without reasoning is not a judgment in the eyes of law. Now we have seen in so many cases, especially in quasi-judicial body, that they are writing various facts, various argument of both the sides, and then they are saying he is guilty or he is not guilty. So the point is, this type of judgment we have seen so many times. Now the time has come. You can write 100-page, 200-page cases, and in that case you are not giving any reasoning. Then this judgment is not the law in the eye. It is not a judgment in the law, eyes of law. So Manoj, what is this case and how it will impact the entire situation?
So I think there is nothing new in this case. It is simply saying that all quasi-judicial body or court of law should pass a judgment which is reasoned judgment. Judgment, basic concept of judgment is you are listening to the arguments of both the sides by of lawyers, if there is any, and based on that you are making your decision, and that decision should be told to all the parties involved, and they should know how you have arrived at to that conclusion. So conclusions, simply writing the conclusion may not be sufficient, because then there is no opportunity of going in appeal. What will be the basis or grounds for going into the appeal? So that was the basic concept, and hence it is a well established principle. But NCLAT has reiterated the fact in this insolvency matter, where it is saying that if a judgment is written without giving reasoning, then it will not be considered to be a judgment in the eyes of law, and hence it is null and void. So it was reversed. It is in the case of Gandhar Oil Refinery India Limited. This is a matter of insolvency where appeal was made before the NCLAT, and the NCLAT has viewed the judgment, and after analyzing it, found that basis of passing the judgment was not given in the order of National Company Law Tribunal bench, and hence it said that this is not a acceptable judgment and it is being reversed. So principle is very well settled. All the judgment should be speaking judgment, so that the party who is getting affected by the judgment should know that their arguments have been captured, have been considered, and after considering their views, their arguments, or the argument of both the parties, judge has come to this conclusion. So that is not there, then it is not a judgment, it is just a simple law. And even if the NCLAT has gone on to say that even if it's simple law which is being reiterated, it cannot be without any reasoning. So giving the reason is very important, and that is very welcome judgment.
Okay. So Ravi, do you think that this is a basic principle when we study law? It is, and you are the, when you read the Chandragupta decision making process, where you are listening both the side and giving judgment and giving
Yes.
a logical judgment. That is a principle since ages.
Yes, it's
But
a principle.
yeah, why this need has arose now today?
So you see, because partially due to the situation in which we are caught up, there are such number of cases. I will not shift all the blame to the tribunals also. I would shift the blame on lengthy and verbiage pleadings, long and unnecessary arguments, because of which it becomes really difficult to write those judgments and dispose of hundreds and hundreds of cases which are listed on the board. But that being said, it needs to be fixed because this goes against, or this is antithetical to imparting justice. We pay a lot of homage to justice, lot of respect to the concept of justice, but justice is just a child. Reason is mother. So if mother is not there, if you can't trace the mother, the child is illegitimate. So therefore, reason, that is why reason is given so much of importance in judicial corridors.
Okay. Okay. And so this issue will be applicable across, and people will be more wise, or Supreme Court has to put a stamp on this?
So in fact, this is a principle.
Sir, I think NCLAT has reiterated the judgment of Apex Court also here, that this is well-established principle of law. It is not a new thing. They are not saying anything new. It is just reiterating the thing. Only thing is that because there are many quasi-judicial bodies that like NCLAT, where there are different kind of members who may not be well versed with the legal process every time. So sometimes they think that this is a technical matter and we can pass the simple judgment. Like let's say it's a merger matter. If you are finding everything okay, simply say it is accepted and merger is allowed. Similarly, in case of IBC matter, they feel that debt is established, so let the order be passed and company will be admitted. But this judgment would help, would make them think more and pass a reasoned judgment. Whether it is technically a technical judgment also, it should be speaking judgment.
Okay. Okay. So I'm just reading the part of the judgment which is saying the requirement of recording of reason is not only to show that the court has focused concentration on rival contentions and to provide litigant parties an opportunity to understanding the ground upon which the decision is founded. So sometime I lost the case, but why I lost the case, it is clearly mentioned. And the writing a reasoned judgment is also indicating that the judicial body is listening carefully, understanding both the party and deciding. So I think this is a welcome move. No doubt it is a part of Apex Code, but still people are not following, the courts are not following. So by this type of forum, if we can promote and we can propagate like something new has happened, people will understand this. So I think, thank you very much, Manoj, for this giving this. No doubt the judgment is connected to NCLT and NCLT, but it is a part of everything. Now another important case has taken place in the company law, but this is also connected to independent director. Friends, recently one case has taken place where non-executive director are vicariously liable if company makes substandard medicine. I think this is one decision where I'm not agreeing. Okay, people are, because it means what we are doing, we are putting tremendous duty on the independent directors, and you are putting them in a very tricky situation that he should know the operation, he should know the finance. So to just now, we have covered one case where the independent director should know finance, where independent director should know the transaction. Now you are saying the independent director should know the operation also, and he should make a differentiation that what is good medicine and what is bad medicine. It means this is something very different. Until unless the independent directors are aware that this is a bad medicine and you are selling it, then they are responsible. Otherwise, because in this case, they have make the differentiation with the 138 cases and person who is in active operation and non-active operation. Ankit, to you first.
I think, sir, we need to look into from this aspect that it's a it's a very long debate or as to what are the liabilities of a non-executive directors, and different courts have held different positions. I was reading, I think, a Supreme Court decision some day back where they have also held non-executive directors responsible for certain act. While in 138, there are cases that it should not be, they are not liable, but there are some high courts and at district level where they have been made accused as part of the case related to 138. So there is not still clarity in terms of what needs to be considered while placing any liability on the independent or non-executive director. Even in MCA in 2020 issued a circular to its own office bearers where they had directed that in case of defaults under the provisions of the Act, not to issue show cause notice to independent or non-executive directors unless and until there is enough evidence to satisfy that there is some kind of connivance or they were part of the. But still, we continue to see that as and when show cause notices are being issued, it is being issued to all the directors. So if one non-executive director has received the notice, he has no option left but to reply, in spite of the fact that there is a clear-cut SOP where we should not be receiving such kind of a show cause notice. So executive directors, either non-executive or non-independent, the position is very vulnerable, and there is no very standard answer in every case to that non-executive will not be liable. While Companies Act by way of officer and default very clearly describes that in case there are executive directors, non-executive directors are not liable unless and until it's a case of fraud. So this is an important case which was in limelight where Madras High Court in a case related to distribution of substandard drugs held that entire board was responsible, and why they made this decision, the rationale that they took, that to manufacture this drug, the decision was taken by the board. And since it is, Vivek, can you go on to next slide? So since they are directly responsible for approving the drug, they cannot claim that they were not involved in the production of drug, and they have tried to make it different from a check signing case where the non-executive director is not signing their check, as opposed to a case where a board is approving a drug. And we need to make a difference in board approving a drug and then in terms of production, it is a substandard drug. There is a huge difference in both the things. Board cannot approve a substandard drug, and because a drug, unless and until it is manufactured, it cannot be a standard or substandard. So what I understand, the board approved the drug that we would be going into this formulation. It's on some operational reasons at the factory and the manufacturing plant that the drug was finally, the outcome was of substandard nature, and there were some tragedies on account of that. So in a case which was filed against this company, apart from the executive directors, the High Court make party all the non-executive directors also, and I think they have convicted them. Ravi, they have convicted them, I understand?
It was a quashing application. It was
Okay.
for quashing of the FIR and charge sheet complaint.
Okay.
Yes. So they have rejected the 482 application. Yes.
So
I think
now
it is not the case that the Supreme High Court has made them convict. They are simply saying that they should be tried. And after trial, whatever be the outcome, they can then appeal. So
Yes.
at this stage, they will not simply grant them exemption from this trial process. That is what the court has said. So,
Yes.
But what needs to be looked into, Manoj, whether they were involved into this?
yeah. So
Production of
prima facie
substandard
something,
There is one.
there should be something on record prima facie which says that they were involved in the connivance. They were involved in the process of deciding that okay, koi baat nahi, substandard hai, but we will throw into the market, something like that. Or they would have the knowledge that the machines are not good or
Yes.
supplies are not good, and still they allowed this to be sent in the market. So there may be something on record. We are not in possession of those things, and hence based on that they have given this judgment that they should be tried at least.
Very interestingly, and I'm saying it with all deference, but with the sense of responsibility, because the consequences of this judgment is far reaching. You have a statutory provision in terms of section 149, subsection 12, couple of circulars from Ministry of Corporate Affairs. Then you have the provision. If you look at the last page of this judgment, under which these 482 petitions were dismissed, that section is section 34 of Drugs and Cosmetics Act. The provision is verbatim written as the corresponding provision of liability under Companies Act is written. It says, where an offense under this act has been committed by a company, every person who at the time the offense was committed was in charge of and was responsible to the company for the conduct of the business of the company, as well as the company, shall be deemed to be the guilty of offense. So therefore, it is at pari materia with the language used in Companies Act. Now, there is no reason recorded in the order as to why the drug was called substandard. This medicine was of thyroid. It was a carbimazole tablet. There is nothing recorded in the order why it is substandard and what is the degree of substandard. Whether it is life-threatening or it is poisonous, it is toxic, there's nothing like that. It is not even recorded that it is unfit for consumption. But to then take an assumption, and there is nothing in the order which says that the decision to manufacture this particular medicine was taken by the board of directors in a board meeting. It's a general statement running in one of the paras of the order, which says that because the decision to manufacture drugs by a drug manufacturing company is the decision of its board of directors, therefore they have to be liable for the production and all the batches, each and every last piece of the tablet or capsule, whatever they are producing. Now, that is really pushing the envelope too far. And I feel that is also contrary to the rule of law and the jurisprudence that has developed, as if the board of director has to work on the shop floor and then come and finalize the accounts and see each and every process virtually that company undertakes to do its commercial transaction or to do the trade and business in which it is operating. Therefore, I think the court has pushed the envelope a little too far in this matter. And surely if appealed in Supreme Court, this is going to be reversed or remitted by the Supreme Court to this Kerala High Court.
Okay, one question has come, Ravi, on this. How can an individual with an expertise in guiding the board by his wisdom and experience can be held liable for the production of a product which is substandard on which he has no control or has no technical knowledge on the same, and they are policy makers and not executor? Your view. Now, after reading this question, you can give answer. I think
while discussing, we replied to this fact, and Ravi also clearly mentioned.
No, I'm just saying what will happen that companies will ask the director, independent director, who is expert in this industry, please join us. So now, till today,
Sir, a lot of companies do so, and they have directors on the board which are expert in their industry.
They have a diversified. They are saying women should be there, where they are saying director should marketing knowledge should have director from IT knowledge, director from the operation. They are finance knowledge. They are not saying all directors of business operation should come. So it means that if you are making responsible, so the two scenario will come. You have made responsible to all director. Tomorrow the time will come. Okay, who is the director who knows about the medicine? Suppose Ankit is the director, so he will be the guilty along with the promoter or along with the executive team.
So I think this can be answered in the sense that the person who is responsible for policy making, if the fault in the product is due to the fault in policy making, if the fault goes to the root of the matter, then the policy makers are at fault. But if in the process of manufacturing, delivering, creating that product, some individual, a group of individuals do some mischief or commit some negligence, and because of that the product is defective, or due to beyond control reasons the product is defective, then they should not be held liable. And this is a fact which should be adjudicated. In a case like this,
Right.
why the medicine was substandard, what was the degree of substandardness. All these questions are crucial questions of facts which needs to be determined.
I think,
And
yes,
that is what High Court wanted by not
that is
questioning the
that
FIR.
is what the
Let's
court
go
actually,
into trial and find out what was
yes,
their actual role.
actually,
But
yes,
it would lead to
actually,
certainly a harassment of
But
the
then
non-executive
the
directors too.
rule is that you don't prosecute the independent or
Hmm.
non-executive directors. That is the rule.
so we have that depends upon the investigation team which have carried and which have alleged these persons to see is to prove or place before the court, junior court, where the matter is first listed, that there are certain prima facie evidence that they should be tried. Then they should allow the court, the junior court, the first level of court should have allowed it. But if it is allowing, I think High Court is very cautious giving this kind of exemption or
482.
relief
Yeah.
to anyone. They don't want to interfere into a criminal investigation process at any initial stage. That's why it is a very common practice that they don't look into anything. They simply say, okay, go and get tried, and after trial, if you are not guilty, you will be adjudicated. But the problem is in India, the trial is the punishment. That is the biggest challenge.
Yes. And in this matter, the High Court order records that the complaint against these people and the company does not record any reason. It simply says the drug was substandard, therefore this prosecution. No reason has been attributed, no role has been attributed to all these accused persons who are, and two of them are staying in Australia. They are residing in Australia. These are foreign directors, not even non-executive. Therefore, I mean, there is something called manifest error. And this is, I think, one of those judgments, those could be called result of a manifest error of judgment.
Manoj, your point is that Madras High Court has not only refused to quash, they have not gone to the merit of the case. It is left to the trial court.
It is, they have left it to the junior court, to the first level court, session court, or even session before that, metropolitan magistrate, to look into this, whether they should be made party to this trial process or not. But they are not willing to interfere here. That is the only judgment I could have found from the judgment. They are not interfering it.
Yeah, medicine when produced is cleared by Drug Controller Authority, and many such checks and balance are there. I think it will have a serious repercussion. He's right also, because that you are finalizing and then approving, then somebody producing. So in between something is happening. So various things will take place. So I think whatever for today was in the last month has taken place, we have covered. So I think thank you very much to all. All the questions which have come, we have given answer. This month is one, I think, because of Diwali vacation, the regulator was also not very active. So we have very few amendments, few changes, and a few case law. So friends, this journey of our knowledge sharing will continue, and this is one model which I'm thinking people are writing to us and they are saying this is a best model. If in the month I have left out something that you are explaining, and we are trying to improve further. We are internally discussing, we are discussing with the speakers. If you have any suggestions to improve this, because we want to make it one program on first Friday of the month, that if you are not able to read or something has missed out or some interpretation issues there, some queries is there, you compile it, consolidate it, and discuss with us, and we will try to resolve this. So this is our main focus of this program, which we want to do it. So friends, as I told you, this is our 99th webinar, and now next is the 100th webinar which we are organizing. So next week, because it's a 100th webinar and it's a big work which we have to arrange. Various speakers are there, various dignitaries are there. So the next webinar we will have only of this 100 webinar on 18th. The next Friday we will not have the webinar because of the preparation issue. I request everybody that please join us. We will send invite also, separate link also. This webinar is indicating the efforts of everyone. I think more than 85,000, 86,000 people registered with us. They participated, more than 50,000 people in last 99 webinar, and more than 5,000 questions we have received and given answer. And there are more than 185 speakers they came for these programs. So I think we have built up a rapport with the participant and the professional which are in the corporate practicing industry people, and this journey will continue. And this 100 webinar is giving a goosebumps to us that we have achieved. We are achieving shortly on 18th. I request you all, whenever we will send you this link, please tell others also to join, and we will start doing this. So thank you very much. Thank you for participating. Thank you.
Thank you.
Thank you.
Thank you.